Might as well say it on the air. America's not going to get right again until our next guest's husband puts his name back on the ballot. But that's a whole other issue. Brenda Talent joins us here on the Big 550 KTRS. How are you?
I'm fine, McGraw. How are you doing?
How's her husband?
He's doing well.
How's the family, the kids?
Oh, gosh, McGraw, they're not kids anymore. They're young adults. They're leaving the nest.
Well, that is outrageous. Say it ain't so. All right, well, tell your husband and the family we said happy 4th of July to you.
And to you.
All right, good. All right, what are we talking about today?
We were going to talk about the appointment coming up for the U.S. Supreme Court. I don't know if your listeners are sick and tired of talking about that or not.
Well, I love playing the parlor game. It's always interesting to play.
It always is. You know, this is an opportunity for the direction of the court to be changed for basically generations, and it depends upon who that appointment is. And I think it's one that we shouldn't be afraid of. I hear a lot of fear out there, and I say that because if it goes in the direction one would expect it to go, you're going to get what is called an originalist on a court. Someone who's going to look at the Constitution, look at its text, construe it in light of its historic meaning, which means that things that should be left to the political process, to the ballot box, actually will be. So in other words, they'll look at the law, say, is it constitutional or not? Is this a proper exercise of legislative authority or not, as compared to the Constitution? And then, if it's not, they'll strike it down, and we get to go back to the ballot box.
Well, okay. In theory, you are exactly right. And, however, first of all, you be careful what you wish for, because you just might get it.
That's right.
Right? I mean, was it Eisenhower who put Warren Burger on the court?
Correct.
And said it was the worst mistake he ever made? Right? And we got a very liberal world after that?
And that is true, because you never know.
Right.
Even though you can look at the jurisprudence of a candidate, a nominee for the court, it is true that it is a life appointment.
Right.
And once you're there are different dynamics that can come into play and affect how you write your opinions.
Yeah, and believe it or not, Warren Burger was Thomas Dewey's running mate in 48.
Right.
So if Thomas Dewey would have won over Truman, you wouldn't have had him to appoint to the bench. So it's a whole cascading of things. But the originalist and the activist court, I have come to believe, is you criticize an activist judge when he rules against your personal beliefs.
There is that theory.
Well, look at Justice Thomas, who said, hey, Obamacare's individual mandate is a tax. And a tax is perfectly legal. And if you don't like it, change it at the ballot box.
Correct.
Right. And so he sided with the liberals and upheld the Affordable Care Act, which you could argue, yeah, you don't like it, change it at the ballot box, which is what they did.
Correct.
So who was the originalist and who was the obstructionist?
I don't know that I would use those particular labels, because one would argue that he sort of stretched the point to find a tax there.
Yes.
But you're right. I mean, you will see, if you will, strange bedfellows when you look at some of these opinions. So, for example, the sales tax opinion that just came down, Wayfair,
right,
where they found that, in fact, South Dakota could impose a sales tax on vendors that didn't have a physical presence in the state. I know this is sort of getting in the weeds here. Yeah. The majority opinion had 4 judges who you would probably say are conservative and 1 liberal. And then the dissent had 1 conservative, what people would say one conservative judge, and the other liberal. And what did they do? They overturned something called stare decisis. In other words, we had a law in the books that basically said to collect sales tax, you need to have a physical presence. Mm-hmm. That's been the law basically since the 70s. It was affirmed in the 90s. It is something that Congress could change. And in fact, many laws went to Congress to change that law.
Right.
And they never changed it.
Right.
But the court came back and said, well, the market has changed. They didn't say basically the heck with stare decisis,
right,
but that's what they did.
Right. So you were saying that was an activist ruling.
Yes.
Yeah. No, you're right. I mean,
although going back, see, there's this whole theory about the Commerce Clause, which again, you could say an activist court developed it, called the Dormant Commerce Clause analysis, and that's what created this rule. And so then you get a court that basically says, we don't believe in that.
Well, but
because it's not constitutional.
Are you a lawyer?
Don't I sound like one?
Yes, you do sound like one. Well, Greg Willard comes on the show, and he's our legal guy. And you lawyers, because I am not one, but it's just fascinating to me. You guys will find the law and use it to your own benefit.
And that's what our clients pay us to do.
Right? I mean, you're like, wait a minute, 2 weeks ago you were arguing this way. And no, you see, because there's another part of this law.
Well, the facts change, McGraw.
Right, exactly. I mean, it's just that's why the law is so fascinating. But I find it a little politically expedient to sort of, right? They're nice buzzwords. A strict constitutionalist, a originalist, until you need Bush v. Gore, and this one ruling applies to this and only this.
But the beauty of it, McGraw, is that actually, if you are a person who is looking at the Constitution, if that's your plumb line against which you're measuring things,
right,
then actually you will always have a defense for why you take the position you take. I mean, some of the language we see out of the court, it's tied and anchored to nothing. It's really your feeling or to some court overseas. I mean, we've seen that kind of language coming from the court. And I get what you're saying, that people can justify what they want to justify or get mad because they happen to disagree with someone and use whatever label. But the reality is that there can be jurisprudence, and there has been, which is anchored in the Constitution. And then you really can say, well, that's just the way it happens. So that regulation is struck down. That regulatory delegation is no good. That particular statutory provision is no good. Go back to the American people and figure out what it is they want.
Now, with that being said, Roe versus Wade is now very much in the crosshairs, and this is going to be a focal point here going forward, depending on who gets nominated, who gets elected in, or who gets enough votes to be put on the court. And a lot of people don't realize this, Brenda Talent of the Show Me Institute, is that if the court decides to overturn Roe versus Wade, it automatically, and this is a question, not a statement, does it not automatically become a states' rights issue?
That's what most individuals would believe. And I think that both people on the left and the right who care about judicial scholarship would say that decision was poorly written and not anchored, again, in any kind of constitutional basis. But having said that, I also think that when we look at this process, you hear both sides saying, well, we're going to have basically a litmus test. That's not the right thing for the person who's being nominated. I mean, it would be incorrect for an individual to come before the Senate and basically say, this is how I would decide a case, right? So I think, again, there seems to be hysteria that's out of proportion to this process. I think that we should all be glad we have a process that will be broadcast, that we can all watch this individual. They'll be fully vetted, and we'll see whether they have the right temperament.
But it's a nudge, it's a nudge, wink, wink, right? I mean, there are cues, there are, I don't know, there are all sorts of interesting things. But you're right. Being asked that question, it's a ridiculous question. As much as we want to know the answer, they don't deal in hypotheticals, right? They deal with the
facts that are before them in the case.
But if it were to be overturned, does it then not become an individual state issue? So they might say, Roe versus Wade, we have changed the precedent. It is no longer the federal court's decision that abortions are legal in the first trimester. It would then be up to the individual states to decide.
That would be my guess.
Yeah.
That would seem. I mean, even at the time that Roe v. Wade was being considered, that was the speculation that would be the result of that case, rather than the direction that it went in.
Yeah. So I mean, this is just and in some ways, it's such a contentious issue. Why not put it on the ballot? Why not have people stand up and vote and have the voters decide?
And I think that, the other part of all of this, obviously, is that when you're looking at these kind of cases coming before the court, if you look historically at the Supreme Court, they don't just, at the drop of a hat, overrule precedent. I mentioned the one case, the sales tax case, but when you're talking about some of the cases that have come before them, it would be odd to see them again with a case coming before them just at the drop of a hat say, we're going to reverse the direction that this country's been in for a number of years.
Except they changed precedent last week with the Janus case and the unions?
Although that case has been argued before the Supreme Court multiple times, that issue has been up there. And actually, when you look at First Amendment rights, you actually see the court being very protective of free speech.
Right.
And so that case actually had come up. There was a case like that had come up several years ago where they hinted at the fact that they thought that there were First Amendment issues involved, but that hadn't been squarely presented to them. Then they had a case it would have been 2 years ago when Scalia died. There had been a case argued on this very issue, and the court came out 4-4 on that one because Scalia had passed away. And then this one came up. So you could see the writing on the wall.
Yeah. That's Brenda Talent, and I know me arguing or debating you with the law is like me bringing a knife to a gunfight, so I apologize.
No, McGraw, you do very well.
Really? She wouldn't say that if I was in class. She would say, back to the room, Millhaven.
I said you did very well. I didn't say you won.
There's the lawyer in her. Brenda Talent, CEO of the Show Me Institute, showme.org for everything, right?
Yes. Thank you, McGraw.
Happy 4th.